Okay, we're going to call this meeting of the disqualification task force to order. And Mr. Vogel, please, can you do a formal roll call to establish quorum?
Certainly, Mr. Chair. Ms. Basham? Ms. Basham? Senator Champion? Senator Champion? Ms. Dawson?
Present.
Thank you. Mr. Esme?
Present.
Ms. Evans? Ms. Evans? Mr. Geffen?
Present.
Mr. Hanson?
Present.
Ms. Huntley?
Good morning, present.
Good morning. Mr. Urban? Mr. Urban? Ms. Kaser?
Present.
Mr. Kammer?
Present.
Lieutenant Knox?
Present.
Judge Kulik?
I am present.
Thank you. Senator Matthews? Senator Matthews? Ms. Mattson?
Present.
Representative Mueller? Representative Mueller? Inspector General Modi? Inspector General Modi? Mr. Page? Mr. Page? Ms. Robertus? Ms. Robertus? Representative Robbins?
Present.
Thank you. Mr. Sandoval? Mr. Sandoval? And I see, Mr. Chair, that Ms. Evans is coming into the room, so I'll count her as present. Judge Satterback?
Present.
Ms. Sherlock? Ms. Sherlock? And it looks like we have Ms. Basham as well. Mr. Tatum?
Present.
Thank you. Ms. Williamson?
Present.
All right, Mr. Chair, counting our arrivals, we have 16 members present, so a quorum is present.
Thank you so much, Mr. Vogel. I know that you have, before we do anything with previous meeting minutes, you have a brief discussion just about open meetings and moving forward.
Mr. Chair, if I may, before he begins, just a point of clarification. You stated that this is a meeting for disqualifications. I just want to clarify that.
Thank you so much. This is the Human Services Background Study Eligibility Task Force. And thank you so much, Ms. Williamson, for the correction.
All right, thank you, Mr. Chair. So I just have a brief statement to read, essentially to get this issue on the radar of the members. And I and Ms. Weber from the LCC are available to answer questions regarding this. So as the legislative session concludes, the LCC is considering the best approach for meetings held during the summer and fall. Meetings will continue to permit remote participation as allowed under Minnesota statutes 13D, which is the open meeting law that governs the task force, and may include options for in-person participation. We will keep you apprised of the format of meetings going forward. So sort of the key line there is the potential options for in-person participation. So that's what I've got.
Any questions for Mr. Vogel or LCC staff on that? Okay, I'm sure Mr. Vogel and others will keep us apprised to any changes in that. But moving forward, a copy of the May 6th meeting minutes was posted to the task force website. And if any of you have any corrections, amendments, changes, comments, now would be the time to raise them. Any input on the May 6th meeting minutes? Okay, seeing no comments, we will now approve the meeting minutes as distributed. Thank you. We have a new member to our committee, and it's Miss Michelle Basham, who's here today from, I want to call it Rehab Services, but I know it's a part of DEED. And before I mess it all up, Ms. Basham, if you wouldn't mind just introducing yourself, you certainly have a significant and important history with these laws and areas. So if you wouldn't mind.
Thank you, Mr. Chair and members. I am honored to be here. My name is Michelle Basham. My current role is I am the Deputy Director for Vocational and Rehabilitation Services, which is a department within DEED, Department of Employment and Economic Development. So we work to ensure that youth and adults have meaningful and integrated employment opportunities in the state of Minnesota. I've run several different nonprofits over the years, and I also previously issued the final decisions in contested case licensing appeals at DHS when I was an attorney there, which of course involved the background studies statute. And I'm also an attorney by training, and am also an adjunct professor at Mitchell Hamlin School of Law.
Thank you so much, Ms. Bassman, and of course, welcome. I think your background is so perfect for the work that we're doing. Moving forward, we're going to have some check-ins from each of the subcommittees, and maybe before that would just sort of describe that we, as we discussed, we do have a new subcommittee. The data analysis subcommittee is now formed. I wanted to identify that there were more people that had wanted to be a part of it than and ultimately were able to. We decided to keep it very, very small, and it is a time-consuming, rather meticulous endeavor, and that work is underway. The chair of that subcommittee is Mr. Cameron, and I just am so excited to have that group together working on crunching numbers and doing some of that hard lifting and heavy lifting. I'm not anticipating today any report from that group, but in the near future, unless Chair Cameron, you had something. I don't think we had tasked you with it, but obviously we want to open the floor up at some point if you have something to report, or wait till subsequent ones. I'll defer to you. I'm going to mix it. Oh, Mr. Cameron. Okay, I'm going to mix it up a little bit. We normally start with the disqualification, and that's usually me, and that just, it seems like you hear my voice too much. So we're going to switch it up, and we're going to ask remedies to start. Mr. Austin, you aren't working on your PowerPoint right now. Are you able to proceed?
I am. I actually did, I'm not gonna lie, add one small thing as you were talking, but I did have it all done. I just realized I wanted to add something.
I'm gonna go work on mine real quick. Okay, no. All right, please, Ms. Dawson, and remedies. Thank you so much.
All right, so I'm going to attempt to share my screen. And it's been a long time since I've given a PowerPoint presentation. So I think probably since law school, and that's been a few years. So I apologize. And if for some reason I can't seem to, hold on. I'm having problems. Let's try again. Oh, there we go. Did it work? I'm seeing nodding. Okay, good. All right. So this is, oh, it's timing me. I don't want it to time me. I don't know how to turn that off. So we're just going to start going. All right. So this is just as we've checked in before and in previous weeks, the remedies subcommittee for the last several sessions has focused on the permanent disqualification portion of the statute. And just so you all know, I was lazy and put DQ throughout the entire PowerPoint because I did not want to type disqualification many times. So we'll just giving you fair warning. So what we have been looking at, and I apologize, I know it's very little font, but we have been looking at specifically the permanent disqualification statute, which is 245C.15 subdivision 1. So this page here is just, when you look at it on the legislature's website, it is all smushed together in one little paragraph. And so just so everybody can kind of see it pulled out and bigger, as big as I can with the number of offenses, just sort of see how many crimes this covers. And so obviously this took up quite a bit of space. and I'll get into more detail on some of these here in a second, but the permanent DQ statute really covers kind of our main sort of the really, for the most part, bigger crimes that people would normally think of, your murders, your criminal sexual conducts, some of your greater offenses regarding minors, for example, use of minors in a sexual performance, possession of child pornography, things like that. So that's kind of just the initial list of crimes. Then moving on to the next slide, the list also covers, smushed in at the very end of that paragraph is a little random subdivision that's for child care background studies. If an individual has a conviction that would make them ineligible for employment under this federal statute. And so what we went ahead and figured out in our subcommittee is this is really the child care block grant. That's what this is really looking at. The federal, the permanent statute also covers all aiding and abetting, attempt, or conspiracy crimes that are part of that, that prior slide, which had the list of crimes. And then based on that list of crimes, also any disqualifications that are based on judicial determinations other than a conviction. So that's your stays of adjudication, things like that. Disqualifications based on a preponderance of the evidence, which I have evidence there, evidences. I'll have to fix that before I send it to Will for posting on the website. And then disqualifications based on juvenile delinquency adjudication. So here we're looking at juvenile offenses as well. So what this tells us when we do break it down is there are actually 37 enumerated crimes plus all, and I kind of separate them out because there's still, in addition, along with those 37, you have all aiding and abetting, attempt, or conspiracy. Based on those permanent disqualifications, we looked at, and that should say 2019. Ooh, it's a few typos here. So in 2018, there were 553 permanent disqualifications, and that was based on a total of 12,639. And in 2019, there were 1,191 out of over 20,000. And just to be very clear, there's the other framework where you've got the 10-year, which are other felonies, the 7-year, which are gross misdemeanor, 15-year, 10 and 7. I apologize, everybody. I was apparently trying to do this quickly and getting interrupted yesterday. So the permanent, and what we noticed in the permanent disqualification list is that there's a lot of kind of background in this based on federal requirements. And we'll get into, as we were doing our research and our discussions in the remedies group, as to sort of concerns that this led us to once we looked at the actual federal requirements themselves. So the federal laws that really pertain to disqualifications are the Adam Walsh Child Protection and Safety Act, the Child Care Development Block Grant, the Family First Prevent Services Act, and Head Start. And the Family First one is really about children in residential facilities. So some of these have these fancy titles and then really what they're about. The point of all of these is that these laws are really linked to federal funding. And I'll get into where these really matter and of course, why they applied and why they were relevant for our discussion in the remedies group. But these are really the 4 ones that are out there. And I know earlier on, and Will, maybe after this meeting, you can resend, the DHS had put together a fairly helpful handout that really kind of looked at these as well. So just so you all know, that information is out there. So the Adam Walsh Act, and I'll break it down here in just a second, but really this is what the Adam Walsh, this is just strictly the language from it, which again, kind of like our permanent disqualification list, is a whole bunch of information smushed into 2 paragraphs. So what does it mean? Adam Walsh, when we break it down, there are permanent disqualifications if the individual has a felony conviction for child abuse and neglect, spousal abuse, crimes against children, including child pornography, crimes involving violence, including rape, sexual assault, or homicide, but not including other physical assault or battery. And then on top of that, it is a 5-year disqualification from the date of the incident if the individual has a felony conviction for physical assault or battery or drug-related offenses. So what does this not cover? It does not, federal requirements do not actually cover gross misdemeanors, misdemeanors, or non-convictions. So these are the stays of adjudication, preponderance of the evidence, and even in fact, juvenile delinquency adjudications. So that's just sort of the breakdown of the Adam Walsh. And I think as we've all been talking about this now for a matter of months, this is obviously, or I'm hoping this is obviously very different than our current statutory framework. The next one is the Child Care Development Block Grant. Under this one, there are permanent disqualifications if the individual has a felony conviction for homicide, child abuse and neglect, crimes against children, including child pornography, spousal abuse, crimes involving rape or sexual assault, kidnapping, arson, physical assault or battery, or violent misdemeanors committed by an adult against a child, including child abuse, child endangerment, and sexual assault. Then there's a second group that's a 5-year disqualification from the date of the incident, if the individual has a felony conviction for drug-related offenses. There's also, kind of when I went and actually looked at the language of the Child Care Development Block Grant, there's sort of this indeterminate kind of time period. It's not totally clear, but I think it's sort of an ongoing, that if somebody refuses to consent to the process or makes material of false statements, they're not eligible for employment. Or if the individual is registered or is required to be registered as a predatory offender. What it does not cover is it does not cover just your standard gross misdemeanors, most of your misdemeanors, and then any non-convictions for preponderance of the evidence or juvenile delinquency adjudications. So I think kind of this theme has started to come up for us in the remedies subcommittee of we're really seeing this permanent list and then simply a 5-year list, which is of course very different again than our statutory framework. And it's really linked to what I guess I would call those more violent crimes that we're really looking at, where there's that actual person involvement, and really where it's that personal involvement, and even more so when there's a child involved. So then there's the children's residential facilities. And as I dug into it, it really appears that it more mirrors the Adam Walsh Act. So I'm not going to say any more about that just because we've already covered it. And then the Head Start program, which actually more follows the Child Care Block Grant. Again, won't go into that in any more detail. That handout that I saw Will already sent, because he's fantastic, does break that down again. So what we noted then in the remedies subcommittee was that the current statutory framework, our current statutory framework, applies to all background studies, despite there being no federal requirements for individuals that work with adults. Our permanency list also includes crimes that are not required by federal statute, which I'll get into here in a second. And this is actually something that I noticed actually this week. So I apologize to the remedies subcommittee, but our statute actually does need to be updated, I think. And that a child torture statute went into effect in September of 2021. And I have a feeling that definitely applies on the permanent list. So that's more just a noted update. So what we noted of permanent crimes that are not required by the Adam Walsh Act. Criminal sexual conduct in the 5th degree. Right now, our statute, our permanency statute simply includes just the actual crime of criminal sexual conduct in the 5th degree. And in fact, the CSE 5, as we call it in the criminal world, is actually, there's one portion of it that's a felony, but otherwise it is actually a gross misdemeanor. And so it actually would typically only be a 10-year disqualification under our current framework and is not required by Adam Walsh. And just to note, as I went through, just as we're all kind of thinking about if this were to be changed, how many individuals, how many background studies is this actually affecting? And so when I looked at the data that we had received, that the criminal sexual CSC 5 covers 153 individuals or 153 background studies in 2018 and 2019. And that is all disqualification. So that's all background studies, whether it's a delinquent, an admission, an Alford plea, a conviction, a POE. When we're looking at criminal sexual predatory conduct, really where, again, some of these statutes, it's a blanket inclusion in it, where in fact, it would not actually be required. And I'll tell you, just in general, there were 0 background studies for this criminal sexual predatory conduct in 2018 and 2019. Incest, it was those less, all I know is it's less than 20. They were the less than 10. So again, we're talking about a very small amount. Violation of the predatory offender registration laws was 42. Great bodily harm caused by distribution of drugs. I was actually surprised by this. I thought there were some, but I didn't find any. So again, we're looking at something that there were 0. Solicitation, inducement, and promotion of prostitution. This is where we're looking at adults, not children, less than 20. And then felony harassment or stalking, we're looking at less than 26. And so again, the other thing that we noted is that the federal requirements don't actually require, or don't look at, you don't have to consider anything less than a conviction. You don't have to consider, and that would include preponderance of the evidence, and you don't actually have to consider juvenile delinquency adjudications. So we just noted that our statute is bringing in more people than's actually federally mandated. So with that, then, of course, we had a number of conversations about what makes sense, especially when we're looking at, we can definitely understand and appreciate when there are children involved and there's this federal funding that maybe make one requirement. And so one of our proposed recommendations is just simply that the Background Studies Act should comply with federal statutes such as Adam Walsh or the Child Care Development Block Grant, but be limited to a list of the disqualifications that are actually necessary to comply with those federal statutes. One thing that we don't know and that we were still waiting to hear back on was whether it makes sense to simply just combine those for all the Adam Walsh and Child Care Development Block Grant, or if they can actually be separated out individually. We just don't have that. Request had been made and we just did not have that answer yet. So this was recommendation number 1, just that we clean this up so that it's really more in line with the federal requirements. Number 2 was that background studies that do not need to comply with federal law, that the legislature adopt the 2008 task force's recommendation that permanent disqualifications be limited to murder, manslaughter, and felony criminal sexual conduct. And I know that the report had been sent out previously, but the report noted that people should be evaluated individually. Ex-offenders should not be barred from any employment, wholesale, and for life, especially when there's no clear nexus between the crime and the job for which the person is being evaluated. So it's really allowing people who may be qualified and who may be appropriate for a position to actually do the work. Proposed recommendation number 3 is to further remove any permanent disqualifications altogether for substance abuse use disorder related positions and facilities and family caretaker positions, and any disqualification based on conduct engaged in by a juvenile. So again, this is more in line with the federal requirements, where the federal requirements do not require permanent disqualifications for juveniles. We're really only looking at adult. And just to be very clear, the family caretaker, we're looking at those PCA positions where maybe the family member is already in the home And so they're already there, they're already helping. It just makes sense from that standpoint. And then to just lastly, remove any permanent disqualifications for positions that do not have direct or unsupervised access to vulnerable people. And those are the summary of our recommendations.
Thank you so much. We'll open it up for questions or comments. I see Mr. Esme, your hands up, please.
Yeah, I was just going to add one more thing that was sort of a point of clarification. When we're talking about removing disqualifications, so both the sort of the bucket for or the three buckets in that last slide for family caretaker and alcohol chemical dependency and juvenile, where we're recommending there not be any permanent disqualifications for those categories. And then this also applies to that other big bucket, which is basically everything else, which we're recommending adopting the 2008 task force recommendations. So both of those, we are talking about removing crimes that are now permanent disqualifications so that they're no longer there. And just to be clear, what we anticipate then happening is not that those would not be disqualifications, they would just be disqualifications at whichever the next longest disqualification tier is, which is something that the disqualification subcommittee, our understanding, is working on. So essentially, for those jobs, those crimes that are now permanent disqualifications would, going forward, if our recommendation was adopted, have an opportunity to time out.
And this is for Ms. Dawson and Mr. Esme. So when you talk about this idea that you look at individuals sort of as they are later in life, just logistically, how does that happen? If someone has a background study, is that analysis of who they are now completed before they're disqualified, or is that part of the reconsideration process?
And I think I can just jump in there. We're just saying that the legislature should adopt the 2008 recommendation, which really their support for their recommendation was just simply that there's not this wholesale DQ process where people are permanently disqualified. I think it's just kind of how that process, I would say, is probably more for the disqualification. Well, and at some point our group will be talking about maybe that's probably our third bucket of conversation further on, partially for remedies too. But I think at least preliminarily for the permanent portion, it's just simply that saying the recommendation should be adopted and simply the spirit of why that recommendation was made.
Understood. Other questions for remedies? Okay, if somebody has their hand up, I'm not seeing it. Okay, we're going to move on. Thank you so much, Ms. Dawson, for all of your work and everybody's work on remedies and your presentation. That was really helpful. And Mr. Vogel will post that then on the task force website for anyone who wants to look at it afterwards. Okay, Chair Williamson, can you give us an update on data, if you could, please?
Yes, good day, Chair, and all
Good
the
day.
members and everyone in attendance. With the data subcommittee, we are elated that we are able to focus on gathering the data. Very happy for the data sets that we've received. We are notating the time frame that it's taking to receive such data sets in regards to looking at considerations for recommendations or proposals or recommendations regarding support for some type of infrastructure data team or data mechanism that would assist in regards to providing data in a more timely or efficient way. We also are with the start of the data analysis subcommittee, which I know Member Kammer is going to lead very, very efficiently as well. We don't see a need to continue to meet bi-monthly and looking to just meet monthly as remedies and disqualifications and the new subcommittee are diving more into the work. We will be ready to receive any information about additional data that needs to be gathered so we can formally make those requests. And if there's anything I'm missing, anyone from the data subcommittee, please add.
Thank you so much, Chair Williamson. Anybody else from data have anything to add, or anyone from the task force in general, questions for data? Okay, seeing no hands raised, we're going to go to our disqualification subcommittee. Mr. Vogel, I'm hoping I can share screen, but let's see. Are people able to see that?
Yes, Mr. Chair. Or
Oh,
at least I
brilliant.
can. Yeah.
Oh, I'm so proud of myself. Okay, so we're just going to give an update on disqualification. And, you know, one of the things we want to first say is we've sort of finished our analysis, our first analysis of juvenile records and how they're used in the disqualification statute and the Background Study Act. One of the things we realized is that we've become pretty familiar with some terms within the subcommittee and want to make sure everybody understands those terms, make sure that our community partners out there are aware of, you know, when we use a certain term, what it means. So we're going to go over a few terms and ideas. We're going to go over what a juvenile record is. What is this idea of extended juvenile jurisdiction? When can an individual juvenile be certified as an adult? And if tried as an adult, is the record still a juvenile record? All right, juvenile court is a different thing than criminal court, although they both deal with individuals who participate in what's deemed unlawful conduct. The juvenile court system is sort of codified and in statute at Minnesota Statute Chapter 260B. And basically it identifies that this juvenile court system, which is different in focus and in intent and function than a criminal court, identifies and works with individuals generally who are under the age of 18 and who engage in some type of unlawful behavior. In contrast to the adult court system, a juvenile proceeding, again, is not a criminal proceeding. It's not really designed for punishment, but it's a civil proceeding where we're trying to protect individuals from themselves and others from that individual and help that person become a lawful adult. It's focused on rehabilitation, but also has a component of public safety, but different ideas than our criminal court system. And when we talk about juvenile delinquency, a juvenile delinquency determination is not a criminal conviction. It is a determination that somebody engaged in unlawful conduct, but the system, the juvenile court system, is identified it as explicitly non-criminal. So when we talk about juvenile cases, that's essentially what we're talking about. We refer quite often to this idea of extended juvenile jurisdiction, or EJJ. And EJJ came around, it was enacted in 1994, sort of focus on public safety for individuals that were committing more serious offenses as youths, and where we as a society at some point felt uncomfortable letting go at 18. And so the idea is there's sort of this dual sentence where the court can issue a sentence that both has a juvenile disposition and an adult sentence. The idea is that if the juvenile follows the disposition and the court's sentence, the juvenile court sentence, then it stays in juvenile court until that individual is 21 years old, at which time the case would be dismissed and court supervision ends. But if the individual fails to follow the terms of that juvenile court sentence or disposition, then it would shift, and that individual would be determined to sort of fail, and the EJJ in the case would then go to an adult court. And so the individual would no longer be under jurisdiction of that juvenile system, but moves into the adult system. It's possible to include an individual in the EJJ if the offense was committed after the individual's 14th birthday. And it only applies to cases that if they were in adult court would be a felony level offense. So the idea, extend the jurisdiction past 18 years old for up to an extra 3 years in cases that are a little bit more serious, or maybe the individual is, I don't know, 17 and a half, and the court wanted to have a little bit more control over the individual to ensure public safety was taken care of, and that that individual was fully rehabilitated and didn't pose a threat. So when we say EJJ and extended juvenile jurisdiction, this is what we're talking about. So we know that some individuals, some juveniles are tried as adults, and that's a process, and it doesn't apply to everybody, and is an important thing to understand who's eligible for it, how it works. And certain juveniles can be certified as adults, and then if you're certified as an adult, once it's certified, you leave that juvenile court system and you enter the adult court system. And so once you're in the adult court system, it doesn't end at 18, it doesn't end at 21. There's no age limit end. And obviously you're dealing with you might be set to adult prison, and you are really treated as an adult. And it's only available in certain situations. The charge would have to be such a serious charge that it would, if in the adult court system, it would involve presumptively a prison time, and therefore not all charges are eligible for certification as adult, only some. There's a separate trial to determine whether the prosecution can certify the individual as adult. If the child's 14 or 15 at the time of the offense, the burden's on the state to prove adult certification. And over the age of 16, it's a presumptive certification, which means that the burden really shifts to the defense to show that the child should stay within the juvenile court system. And again, that EJJ sort of is in the middle. So we have the juvenile system, we have this extended juvenile system through EJJ, and then we have those individuals that are tried as adults. And so what we're talking about now moving forward are some of our, and you've seen these before, but just some of the ideas that the disqualification subcommittee came up with. And we're starting to kind of vote on them and rank them, but here they are, our recommendations. One of the recommendations, Mr. Tatum, do you want to talk now, or do you want to wait? It's up to you.
Yeah, I just wanted to ask a question on that.
Of course. Yeah, on the last one or this one?
Yeah, can be certified as an adult. Yeah, this one here. Yeah, like you said, there would be certain reasons. Would it be like some aggravated factors or something, or what would that look like? For like being enhanced.
So, I mean, the prosecution gets to make a decision whether or not they're going to pursue it. And you're going to have to show that the individual, if convicted of this crime, would presumptively go to prison for it.
Yeah.
And if you're fighting it, and I'd ask others who've practiced in this area significantly more than I, you'd want to show that this individual doesn't pose a threat if they stay within the juvenile system or the EJJ system. Anybody who's done some of these certifications, I know Judge Kulik's been a part of them, I'm sure others have. Does anybody else want to add something to that explanation?
It would have to be a violent act, though, would say? Or
well, I mean, it's generally going to be a crime of violence, but not always. I mean, I think you could have some other offenses that are severe enough. Miss Basham, and then Mr. Esme.
Arson, yeah.
So my comment, thank you, was going to be, one of the things that concerns me about this, as hopefully most of us are aware, there are significant disparities across the country, including in Minnesota, with regard to certification, and BIPOC youth are certified at disproportionate rates compared to Caucasian youth. And so to me, it just becomes continuing discrimination, both through certification and through EJJ.
And I think we have some data on that we'll discuss in a minute, but a really important thing, I feel like that issue, Ms. Basham, goes through so much of what we do, and we need to be constantly coming back to it. And I appreciate you raising that. We'll get to it, but not as well as I'd like to, quite honestly. Mr. Esme.
Sorry. Yep.
Thank you, Chair Geffen. I was just going to chime in on, and I think you're mostly right in answering Mr. Tatum's question, but just to be real clear, so it's the prosecutor has the discretion about whether to motion the court to have a case be certified for adult court. The basic requirements are just that it's after 14 and a felony. But most of the time, you know, just because it's a felony, we're not getting to adult certification. There are some circumstances where once the prosecutors ask for it, it's presumed that it would be adult certification. And that's for our you know, most serious felony offenses. And they're offenses that if they were committed by an adult, under the sentencing guidelines, it would be a presumptive prison sentence. So like if an adult committed it, even with no prior criminal history, you know, they'd be going to, be presumed to be going to prison. And then if it isn't one of those, and even if it is one of those, the prosecutor has the discretion to move the court to do it, but then the defense has an opportunity to present evidence as to why there's not a public safety necessity to have this case taken away from juvenile court and sent to an adult court. And so that's kind of how the process works. And in practice, I think your instinct is right, that it tends to just be the very most serious cases that prosecutors select to try to certify for adult court.
Yeah. Okay.
Thank you so much, Mr. Esme. Judge Kulik.
Well, I'd shared my experience with my subcommittee, but when I had an EJJ certification hearing, there was an EJJ study done by a licensed clinical psychologist who also does some of our competency evaluations. It was incredibly thorough. I had this, 14 at the time of the offense, and the offense was aiding and abetting second-degree murder. So it was a very serious offense, but it was still a fairly young kid. But it was not only his educational background, criminal background, family background. We had his very first diagnosis of being on fetal alcohol spectrum. It dove so deeply into not only his legal background, but his mother's, because she was 17 when he was born. And just a wealth of information that I could use to determine, you know, what I ultimately did. And the prosecutor in that case wanted to try the child as an adult, but I ended up instead denying that and finding that the most appropriate place was the extended juvenile jurisdiction, because frankly, went up to age 21, there's lots of incentive for that child to stay on track and for us to help him stay on track, because he had a state adult sentence of 25 years and he's doing really well. But we got to have him by the time he got into court. We still got, and we still do, he's not 21 yet, he's 18, but he is getting wonderful rehabilitative services, graduated high school a semester early.
Yeah.
Thank you, Judge. I think it's so nice to have your expertise, seeing it from the bench too, and seeing how that process plays out. Thank you so much. Ms. Basham, is your hand up? I didn't know if it didn't come down or.
Sorry, it is, but Mr. Tatum is before me.
Oh, I didn't know, Mr. Tatum, if your hand was up still. My apologies. Please continue.
Thank you. Judge Kulik, she just shared a wonderful story. I had 3 friends like that. My friend Jamar, he went there for a murder. You know, they tried to send him to the to be certified as an adult, but he didn't commit the murder, just being an accessory and right there when it happened. He ended up going to Glen Mills. They sent him to Glen Mills, EJJ. He ended up going to Connecticut, ended up getting weightlifting. You know, he was really good with weightlifting and went to Connecticut and was on the he didn't get to play with the Jets, but was on the, you know, just sitting on the side of the field, you know. So it was a great pathway for Jamar. You know, this was one of my friends that grew up in the old gang life, and and two other friends that went through the process for different various things. So, different pathways, chose to still go and still there, still surviving. So I know it could have been beneficial for them, but if you chose to, use it for a tool, so that EJJ, that's why I said it had bads and goods to it. So I just wanted to mention that, so yeah, I never went through it myself, but people that were really close to me. Yeah.
Mr. Tatum, did the friends that you had that went through it succeed in it and complete it?
Yes.
Okay.
Yes, Karan and also Jamar. Jamar, yeah, he was an excellent kid, 15 years old, got caught up in a murder right away, running around in the hood. My neighborhood. I just was, I was actually kind of, honestly though, harboring him kind of. We were both in active in that gang lifestyle. So at that time, I just felt bad for him. Because I know you didn't do this, but they're looking for you. He ended up going to jail. He was a good kid. Winning weightlifting championships. Came home looking like he was a star. Yeah.
And I want to remind you too that it's always wonderful for us to hear lived experience about these. So if one of your friends is ever available and willing to maybe talk to the committee as a whole and just give us what it's like to go through EJJ. We can talk about it all day, but I haven't experienced it, and probably most of us haven't. So that's an open invitation to your friends.
Definitely, most definitely. I'll let them know about that too.
Thanks, Mr. Tatum, as always. Ms. Basham, please.
Thank you for your comments, Mr. Tatum. I would agree, drawing upon my experience working with youth experiencing homelessness and sexual exploitation, there can be some advantages to EJJ to maintain continuing eligibility for services. However, going back to certification as distinct from EJJ, I want to just caution us when thinking about, well, their prosecutor or their public defender or their defense attorney can argue against certification, again, because BIPOC communities, both adults and youth, historically have much less access to private attorneys as opposed to public defenders with caseloads of upwards of 45 or 50. And nobody can be a good attorney when they have a ridiculous caseload.
Thank you so much, Ms. Basham. Mr. Esme?
Yeah, I just want to echo that as an absolutely excellent point. And as I was trying to explain, but maybe didn't fully explain, the presumption for the cases, most of the cases where prosecutors move for adult certification, you're going to have this presumption, which, it can be very difficult to overcome too, even if you do have a good attorney. So.
Thank you. I appreciate everybody's real experiences in this. Something I don't have a ton of experience in. So just with those definitions and that background, here are the list of recommendations that we've started with. You've seen these before, but I just thought we'll continue to go over them. So one of the recommendations is prohibit disqualification under the Background Study Act for juvenile records after juvenile supervision ends. And whether, I guess that would, if we talk about juvenile supervision, it would mean juvenile court ending at 18, but also the EJJ at 21. Prohibit disqualification based on juvenile records for offenses committed under the age of 14. Use only convictions individuals tried as an adult and extended juvenile jurisdiction, EJJ, for disqualification determinations, meaning that if the case is a true juvenile case where jurisdiction ends at 18, that is outside, since it's a non-conviction, outside the scope of the Background Study Act and could not be used for a disqualification. We also had discussions about the look back period. And of course, the look back period involves how the department looks at convictions and also juvenile cases that you start any kind of waiting period for disqualification, the 7, 10, or 15, based on the date that the individual completes probation or supervision ends. And the recent changes to the foster care licensing statute sort of has it a little bit differently. And you know, Mr. Page were here, he'd remind us more about it, but it's more aligned with offense date and conviction date as opposed to punishing somebody who might have to wait a long time to go to trial during COVID, or somebody who gets just a little bit of a longer probationary period. This was a big deal, I think, in the past when sometimes you'd see 10-year probation periods, not so much with the juvenile cases, obviously. This sort of dips in a little bit to remedies, but to permit the department to set aside any permanent disqualification if it's based on a juvenile record. Currently, all permanent disqualifications, you're unable to set them aside, regardless of circumstances. And then our last one was that regardless of the disqualifying offense, an individual is disqualified for a flat 5 years. So these would be juvenile cases only. These are not the EJJ and cases tried as an adult. The belief being they are the younger individuals with less serious offenses, 5 years in alignment with the brain science, that as individuals mature and get older, they make better decisions, they're less impulsive. And the 5 years, even though this is a juvenile case and a non-conviction, is aligned with the Adam Walsh Act. So those are some of our recommendations. We're sort of stacking them, trying to figure out which ones are better, which ones make more sense. But those are our recommendations. I want to just sort of give an overview of the, oh, that shouldn't say DW, should say disqualification subcommittee. We've looked at juvenile records and now we're switching. Starting next week, we're doing some painstaking work with going through the long list of disqualifying crimes and conducts that are a basis for disqualification. As you know, we have these tiers of, we're not going to do the permanent, that's already been done, but we're going to go through the 15-year list, the 10-year list, and the 7-year list. And we're going to look at two things. And we're going to look at whether or not that crime or conduct should be a disqualifying factor. And if so, how long should it be a disqualifying factor? It's a long list and it's going to take a lot of work. And so we're going to start moving to weekly meetings because we have to really go through each, and we have to identify really with each one, not only what the statute says, what does that really mean? Because we want to convert this to something readable, something understandable for not only the task force, but the community in general. And it's gonna take some work. And then we're gonna do that for a few weeks, and then we're gonna have a discussion of the disqualifications within the foster care system. We have some experts within our disqualification subcommittee that really understand the really detrimental effects on the foster care system with disqualifications. Oftentimes family members who would otherwise be eligible are precluded from participating in the foster care system, which can lead to some really unfair results based on a lot of equity issues, race issues, socioeconomic issues, lots of stuff. So that's what we're gonna come back with. So at the end, we're gonna have three main areas, three buckets, to steal a remedies term: juvenile records, the disqualifying conduct, and then our foster care system. Those are gonna be our three recommendation buckets. As we come back with our recommendations, this is something that the disqualification subcommittee is going to do, and we'll leave it up to the other subcommittees. We're going to start drafting sort of preambles or introductions to our recommendations, including sort of an overview or narrative that will talk about how we got to that recommendation. You know, what we looked at, what guided us. I'm pretty sure I have some very bad typos on that side. Specifically, this word interdictory. I believe it was so bad, spell check didn't even want to deal with it. But our idea is to give people insight into why we made those recommendations. We've studied some facts, we got data, we've heard lived experience from people coming in and talking to us about how their life was affected by the background study, and what guided us, what got us there. And we want to talk about what process was used. And focusing on how this recommendation will not have a negative impact on the health and safety of vulnerable individuals, because we have a difficult task. Our task is to figure out how do we protect our most vulnerable populations without unfairly punishing people that have been impacted by our systems of criminal justice. So we want to be thoughtful about it. We want to be intentional about it. So we're going to be writing for each one of our recommendations in each of those 3 buckets an introduction. And we certainly, the introductions are going to have to be written. And so I think it's a little bit unfair to throw Mr. Vogel in that, to have to write everybody's thoughts and you know, internal thinking. So if other groups want to do that, I'd applaud it. And so as we were kind of going through this, we thought, what were our guiding principles when we were thinking about juveniles? And some of our guiding principles, and we certainly want to make sure that people both within the committees and within our greater listening audience or viewing audience who want to weigh in on this, please give us that input. But some of the things we thought about were that juveniles are just fundamentally different from adults. We know from brain science, we know from personal experience, we make some decisions when you're young that we might not always be proud of, and we might not have made later in life. The Bryan science, well, that's a problem, but Bryan's science supports treating juveniles differently than adults. Bryan is a juvenile, so that's why it's so important. And, you know, with maturity is, you know, not only just introspection and making, but it's a really means a reduction of the risk of harm. And so a lot of individuals who are young making bad decisions turn out to be just wonderful people. I think Mr. Tatum talked about somebody who turned his life around. And I think a lot of people we know and have heard from have done that. And we want them to be valued members and employed members of our society. Also identifying that there are some people who commit juvenile offenses who do pose a risk of harm to vulnerable groups. How do we deal with that? And the last thing I'm going to talk about just is racial disparities. I think Mr. Esme provided some really helpful information from Hennepin County that when you look at, and I'll try to pull this up, but maybe I'll just give you the link, that in Hennepin County from 2018 to 2022, 65% of juvenile prosecutions are listed as Black or African Americans, while 19.8% are identified as white, while the 2021 census for Hennepin County shows 74.2% Hennepin County identified themselves as white alone. We're seeing a huge racial disparity. And I mean, we know that these issues exist. You know, we talk about being downstream, that our criminal justice system has disparate impact on certain communities. But I think what we want to focus too on is, just because you've had interaction as a juvenile, going back to, does that mean you pose a risk of harm to individuals when you're older? And further understanding that this is about collateral consequences, that if you are in a community that's over policed, or if you're in a group that is overrepresented within the juvenile court system, under our current background study laws, it will limit a lot of employment opportunities, a lot of you know, a lot of volunteer opportunities. It's going to have a significant impact on your life, and that means, you know, your finances, that means your family, that means your housing, that means your life, and how important that is. And I'm just gonna, this was my worst slide of the day. That's just the link to the information from Hennepin County. I tried to do a screenshot of it, but failed miserably. And
Mr. Chair, I actually just sent that link out to the members, so you should see that in your inboxes.
Perfect. Thank you. And actually that website has a lot of kind of bells and whistles you can mess around with. You can look at juvenile data, you can look at adult data, and you can look at some trends. I think it's a really interesting thing to review. I've been talking for a while, so I want to make sure that we open this up to the rest of the disqualification subcommittee. Are there things from the DQ subcommittee that I missed, misrepresented, or any additions?
And Mr. Chair, I don't know if you can see it, but Ms. Williamson's hand is up also.
I cannot. I don't know why I can't, but Ms. Williamson, please.
Thank you, Mr. Chair. I just wanted to just hone in on a point that you made from your presentation, just in regards to with the disparities in juveniles, that we keep in mind, you know, out of respect, just there's been lived experience stories given, there's been presentations in regards to the adolescent mind given. I also want to just say that if we're all really honest, there's mistakes or choices that we've all made at some point in our life. And it's not okay with someone's social economic status or race, especially, to dictate whether or not you get away with it. There's a lot of literature in regards to criminals within, or just in regards to decision making. And lastly, just want to say, you have judges, you have presidents, you have different ones who happen to know the loopholes of law or had the money to be able to go forward and live their life. And it's problematic that people, depending on their social economic status or their race and other, don't get the opportunity to learn from their mistakes.
A great point, Ms. Williamson, and I appreciate that. Yeah, I think it's true. If we're all honest, yeah. I mean, I told someone the other day, I don't have a criminal record because I was fast and I just ran. That's the difference. And I agree with Ms. Williamson 100%. Anybody else have a confession? Anybody else have any input that they'd like to add regarding anything to do with data? Mr. Tatum, I see your hands up.
Yeah, there was the other side to that, like as far as the criminality to it. Yeah, I liked being a criminal growing up, watching criminals. Those criminals, those were my heroes, you know. So that's the side she's talking about, and that's reality, and that's real. You know, didn't want to be the other side until treatment got a hold of me and messed my head up. You know, yeah, it took a while processing. Yeah, as far as the change of personality. So it is real. Yeah, I was addicted to the criminal lifestyle, and I loved it. I'm just saying that's where your head goes when you're how can I say, conform to it, learn behavior. You know how it goes. Just wanted to share that.
I appreciate, I mean, obviously, Mr. Tatum, that's why we love having you here. You can provide insight into things we don't know anything about. So I appreciate you very much. Before we move on, anybody else, anything that you think we should know as part of the disqualification subcommittee? And obviously it doesn't have to be here. It could be at any time, anywhere. Okay. That's, I think, Mr. Vogel, do we have anything else scheduled for today?
I don't believe so, Mr. Chair.
Okay. Then I think we'll just open it up to see if anybody else has anything else to add before we adjourn. And nobody wants to be that person that raises their hand at the end of class. We're going to let you out early unless somebody raises their hand. Terrible way to approach it. Okay, with that, as always, thank this group. I appreciate your time. I appreciate your expertise and effort. If you have,
John, I just have one thing.
Of course.
Oh,
It's you. It had to be Gina. Yeah, Gina.
Will you just put the call out to folks that are listening and people that are watching it later? We really do want to get more input from folks and personal share lived experience and all of that, to start adding that to these meetings, especially these Friday meetings.
I appreciate you so much, Gina. That's absolutely right. I had it highlighted and I just didn't do it. Please, people who are not within the committee, but listening, know people. Everything that we do needs to be guided by people with lived experiences, and it helps us a lot. It's a big part of this. And a lot of people have personal expertise, other expertise. Please communicate with us. Mr. Vogel, do you want to put up again one last time how people reach out to how to reach out to us?
Definitely, Mr. Chair. So I'd say there's two primary ways. You can go to the task force website, where also you can find all these things we're posting. But that's lcc.mn.gov/HSBTF. And then if you go to the task force homepage here and scroll down, you'll find this, this ability to submit your story. You can also input your email address to get on our mailing list, essentially to get notifications about when these meetings happen or that sort of thing. You can also navigate to the task force staff page, and my contact info is here. Please feel free to reach out to me if for whatever reason that's how you prefer to get in touch with us. And I can definitely pass any messages along that you'd like me to. So
Yep.
thank you.
And just as an FYI, there's a couple folks on there that have already submitted their stories that we owe some response back to, and we'll do that soon.
Yeah, and I would say to our community, if we're missing something or you have something to add, reach out. The only way we're gonna know more is if you let us know. So thank you. Anything else, Ms. Evans? Anything else, anyone else? Okay, with that, we are adjourned. Thank you all so much again.